Hey guys, welcome to this video. This is John Watts. This is a video going over a case, and this is really more for the lawyers that are watching. But if you happen to file a case on your own involving the FDCPA, the FCRA, I don't recommend that, but if you do that, you may face an offer of judgment. And this is a great case from about a decade ago from the 11th Circuit Court of Appeals, which that's the appellate court that covers Alabama, Georgia, Florida, as far as federal matters go. And so let's take a look at this case because it'll teach us a lesson. And let me just sort of lay the foundation here. You file a federal lawsuit or a lawsuit like we do in state court, it gets taken to federal court. And then on these consumer cases, not so much on personal injury, but on consumer cases, the other side will often present what's called an offer of judgment. This is Rule 68 under the Federal Rules of Civil Procedure. And they'll say, hey, we offer to allow you to take a judgment against us. And the idea behind that is that they offer you everything you're entitled to, then you should take that. You should accept it. Now, if it's not quite everything you want and you reject it, then there can be some consequences if at trial you end up getting less than what they offered you. But we're going to see how this is abused by defendants and how the court rejected what the defendants typically do. So let's take a look at this. So we've got the law office that got sued under the FDCPA argues district court erred in granting attorney's fees and costs to the plaintiff despite an offer of judgment. And they say, we affirm. So let's see what happens here. So there's a one-count lawsuit just saying, hey, you violated the FDCPA, Fair Debt Collection Practices Act. So the defendants served the plaintiff, the consumer, with a Rule 68 offer of judgment. And here's what it said. You'll dismiss the lawsuit with prejudice and execute a confidential release. Now, when it says release, that just means settlement agreement. Just a different way of saying it. So they offered $3,000, basically $1,000 to the client and $2,000 to the lawyers. And so the court says, see, they offered the consumer $1,000 in damages. That is what are called statutory damages. And $2,000 in attorney's fees and costs in exchange for settlement of lawsuit confidential release. Well, the consumer, rightfully so, rejected it. They did a trial and they got $1,000. Now, in addition, the consumer could then request attorney's fees, and ultimately the court awarded attorney's fees of almost $63,000. So you can imagine the law office that violated the FDCPA is just having a complete come apart over this. Like, oh my goodness, we offered, your client $1,000. We offered you, the lawyer, $2,000. You rejected it. And then at trial, your client got the $1,000 we offered. And now you want, and the district court awarded you $63,000. This is so unfair. Well, let's see if it's unfair. So the law office says, based on its offer of judgment, then the consumer should not get any fees or costs. And here's what the rule says, that the judgment that the offeree finally obtained, so that would be the consumer, you're the one that's offered this, is not more favorable than the unaccepted offer, then the consumer must pay the cost incurred after the offer was made. So the law office argues, look, we made a Rule 68 offer of judgment for $1,000 in damages. You got $1,000 in damages, same amount, so you're not entitled to anything. Open and shut case, pretty simple, right? And the court said, well, no, actually not. They said the plain language dictates a plaintiff typically is barred from seeking attorney's fees if you get exactly what was offered. But here's the problem. See, the law firm that got sued got too cute, and we see this all the time. They cannot get themselves to just do a normal offer of judgment, which should literally say the defendant offers for the plaintiff to take a judgment against it in the amount of blank, and that includes all fees, or the court will then determine the fee. That's what it should say. But these guys love to put language in there about we're not admitting anything, we didn't do anything wrong, or you have to sign a settlement agreement, or you have to keep this confidential. all this garbage that we would not get with a verdict. And here's what we're going to ultimately see. The court says, basically, look at the offer of judgment. Now, look at what a jury verdict would be. And then you compare those. Are they the same? Or are there differences? If they are the same and the offer of judgment was equal to or more than the judgment, then the consumer's up the creek. Okay? But if it wasn't, then there's no effect of that offer of judgment. So let's take a look here. They say the offer of judgment contained a condition. Sign a confidential release. Well, guess what? When we get a verdict, there is no release. We don't sign a settlement agreement. We have a verdict, and it's certainly not confidential. It's public. While it is difficult to assess the value of this condition, it presumably was worth something to the law office because they demanded it, signifying that the consumer's ultimate recovery was more favorable. Okay? And then they say, there's public exposure when you get a verdict. That's a good thing to try to prevent abusive debt collection. And then this Wright-Miller Marcus, that's sort of I guess you'd say, the most famous book on how do we interpret sort of civil procedure, which would include Rule 68. And they say it's intrinsically more difficult where one or both involve non-monetary relief. But where, for example, the Rule 68 offer of judgment includes every element of the eventual judgment, a comparison between the offer and the ultimate disposition should not prove difficult. Okay? But it would be best to view the defendant as having the burden of demonstrating the offer was superior. And that's what the case law says. And they say here the office failed to show how the ultimate recovery, which did not require him to sign a confidential release, was not more favorable than the offer of judgment, which did require the release. And so they allowed the fees to be accepted. So here's kind of the take-home message from this. If a defendant does an offer of judgment that doesn't have any of this squirrely language in it, okay, you got to sign a release, or the court will determine that we didn't do anything wrong, or you can only get your fees up until the day that the offer of judgment is accepted, but no more after that. Well, that's not what we get with the normal judgment of verdict after a trial. See, a verdict, there is no settlement agreement, and if they won't pay the fees, then we get into what's called a fee battle. Well, that could drag on for 6 days or 6 weeks or 6 months. And ultimately, the defendant has to pay that, because here's the kind of the incentive. It would be a perverse incentive. If you did not get paid for that as a lawyer, well, every defendant could just be a jerk about the fees and say, nope, we're going to fight you. We're going to appeal it. We're going to make you spend 2 years fighting over these fees, and you can't get paid while you're doing that. Well, that's not what we get with the verdict. So I'll give you an example. We had a credit bureau. This is probably 15 years ago. And they said, hey, we'll do an offer of judgment. And we accepted it. And I'll always remember the lawyer. He's a pretty nice guy. He's like, great, John, I'll work up settlement agreement and get that to you. I'm like, whoa. There is no settlement agreement. I'm getting a judgment against, this was Equifax actually. He goes, what do you mean, John? You agreed to the amount. We'll get you a settlement agreement. We'll dismiss the case. It'll be confidential. I'm like, no. You offered for a judgment. I accepted. I get a judgment. There is no settlement agreement. We're not signing anything. And if you don't pay that judgment, then we're going to start executing against Equifax. We'll go get our money. If we have to go seize computer, whatever we have to do. I'll just say this. They have never, ever made an offer of judgment after that, because all the lawsuits that were similar after that, we would put in the lawsuit. There's even a judgment against Equifax in the Northern District of Alabama on this exact type of misconduct. They hated it. So we very rarely get these. And occasionally we'll get a real offer of judgment. It's the right amount, doesn't have any squirrely language in it. And we're happy to accept those, because now my client has a judgment against the bad guys, okay? But when we're dealing with sort of, amateur hour lawyers that don't really know what they're doing, they'll throw these out there like, John, we made this offer of judgment for $1,001 and you can't get emotional distress damages. I go, how do you know that? Like, everybody knows that. I'm like, tell me about all your jury verdicts. Well, I heard it in a seminar that you can't get emotional distress damages. I'm like, well, we have jury verdicts where we get those damages. They go, well, there's no way you can get them. So this offer of judgment that says we did nothing wrong, you have to sign a confidential settlement agreement. You better accept this or you're not going to get any fees afterward. I'm like, settle down, Sparky. Go figure out the law, and then you'll know that you don't know what you're talking about. So anyway, again, this is more for the lawyers watching this, but just understand it's a very powerful case. It's a very common sense type of case. When people are adding conditions that would be different than a verdict. So that's the way to mentally evaluate that. This is the offer of judgment. This is what a jury verdict would be. If these are identical, then accept it. If they're not identical, then you can have some comfort in turning it down. Obviously, do your own research. But that's the way that we look at it. And, we've been very successful doing this. So it's served us well. So thanks for watching this, and I'll catch you guys tomorrow. Have a good one. Bye-bye.